Nearly 70 years ago today, my fellow countryman, Justice Robert H. Jackson, stood in this courtroom and gave the opening statement for the prosecution at the trial of the major German defendants before the International Military Tribunal at Nuremberg. According to Telford Taylor, a member of his team, Jackson had been nervous and irritable for weeks prior to the opening of the trial, which had almost been delayed several times over his objection. But once he walked to the podium and began to speak, his voice was clear, his commitment was unshakable. No one listening that day or reading his speech afterwards could doubt his passion, his eloquence, his firm commitment and conviction that his role was to bring the rule of law to bear on the question of what to do with the 22 German in the dock that day. Jackson understood that this was no ordinary trial. He knew that the world was watching, and he knew that the world would judge him harshly if he failed. He did not. Jackson, like the other prosecutors that presented evidence to the tribunal over the next 10 months, rose to the occasion. His opening statement, in particular, has been forever etched in the hearts and minds of scholars, activists, and students of Nuremberg and its impact over the decades. Jackson noted that he had the privilege to open the first trial in history for crimes against the peace of the world, a privilege that imposed upon him a grave responsibility. Ladies and gentlemen, your excellencies, distinguished scholars, academics, dear friends, dear colleagues, I feel similarly privileged to stand before you today at the opening of this important meeting of the Nuremberg Principles Academy, on the occasion of the 70th anniversary of the opening of that famous trial, and address you regarding a subject that has been close to my heart and academic work for the better part of 2 decades. While these remarks in no way carry the kind of consequences that Jackson's opening statement did 70 years ago, I do feel a similar responsibility. What is there to be said about an event and its consequences that has not already been the subject of distinguished books, films, articles, and conferences? And what can I bring to your important discussions today as an American observer and commentator on the Nuremberg legacy? Having been charged with the task, however, I hope to rise to the occasion. I will address only briefly the Nuremberg trials themselves and then quickly turn to the legacy, how the extraordinary events of 1945 and 1946 have shaped the world since that time. I would then like to turn our attention to some aspects of the Nuremberg legacy that remain either unfinished or perhaps have tarnished rather than brightened with time, and conclude with some final reflections on what can be done to reinforce the legacy so that we do not find ourselves 70 years hence breathless and ashamed again, as we were in 1945, at the devastation wrought by a world at war, but instead enjoying the benefits and prosperity that flow from our efforts to promote the gradual and unceasing construction of a world at peace. The difficulties that Jackson faced in 1945 remain with us to some extent today, and indeed, rereading the biographies from that period, I'm struck by how many of the same problems have been present at the ad hoc tribunals and at the ICC. Plus ça change, plus ça reste pareil. Jackson was keenly aware of the deficiencies, both legal and practical, that faced the prosecutorial team at Nuremberg. A country lawyer without formal legal training, he had risen to the highest judicial office in the United States as a result of his keen mind and extraordinary rhetorical skill. He knew the case was a novel one, that the precedent for indicting and trying the accused was virtually non-existent, that there were legitimacy questions raised by the specter of having the German accused tried to a bench of Allied jurists by a team of Allied prosecutors. Rather than hide from the weaknesses in his case, he met them head-on. The case, he said, was complex, of course, involving the developments covering a whole continent and involving a score of nations, countless individuals, and innumerable events. As he observed in his opening statement, less than 8 months prior, this courtroom had been an empty enemy fortress, and the accused and the documents were in enemy hands. There was no codification of the relevant law, no procedures had been established, no tribunal was in existence, no prosecuting staff had yet been assembled, nearly all the accused were at large, and the 4 prosecuting powers had not yet joined in common cause to try them. What he did not reveal publicly was that the 4 prosecutorial teams did not work well together. It was an arduous and difficult diplomatic as well as legal process that involved wrangling over differences between common law and civil law procedure, and the negotiators and prosecutors struggled with questions of the substantive law, questions of procedure, with the Anglo-American doctrine of conspiracy, with the impossibility of getting documents translated in time for the judges and defense counsel to receive copies, of the particularity elements required in the indictment. Jackson also had trouble with his staff, many of whom departed either due to conflict with him or for personal reasons, and Telford Taylor describes the staff as being plagued by tensions and petty jealousies, living in an expatriate bubble with little interaction between occupiers and occupied. The Russians were not permitted to fraternize with the other teams, and although François de Monton opened the French case with a stirring and oft-quoted statement, he then returned to France almost immediately, leaving Champetier de Ribes to take on the trial. Moreover, many of Jackson's American compatriots, including members of the Supreme Court that he had left to join the team here at Nuremberg, they were scornful about the utility and the enforceability of international law, arguing that the trials would either make matters worse or at best be but a useless act. The international political environment was also challenging for the tribunal. Just 2 days prior to the signing of the London Agreement and Charter, the Enola Gay was winging its way through the sky en route to dropping an atomic bomb on Hiroshima, and 1 day after the charter was signed, a second bomb was dropped on Nagasaki. The 4 Allied powers had a vested interest in not pursuing charges that would show them in a bad light. Thus, there were no charges relating to aerial bombardment, for example, and the Russians insisted on charging the Germans with the Caton Forest massacre. The press covered the trials, but they said they found the documentary evidence to be boring. Jackson bemoaned the fact that no real arrangements had been made so Germans could attend and learn from the trial. And on March 5th, 1946, as the Russians were finishing up their case, Winston Churchill was in Fulton, Missouri, my home state, giving his famous Iron Curtain speech and ushering in the era of the Cold War. Jackson understood these difficult political realities, but he defended the trials, writing later that what we have done with these men is a question always avoided by those who find fault with what we did do. He and Roosevelt shared the view that the thirst for vengeance would have been amply demonstrated by the French purge of thousands of former collaborators, could, if applied to the Germans, lead to doubt about and denial of the crimes and create a myth of martyrdom. Instead, they argue there must be public proof of the crimes, and the accused must be given the chance to defend themselves. After 10 months of proceedings, the trial was over. The judges retired to deliberate. The judgment they rendered on October 1st, 1946, was impressive. Many of its pronouncements form part of the modern canon of international law, that crimes are committed by men, not abstract entities, that the law of the Charter was both an expression of international law existing at the time of its creation and a contribution to international law itself, that the establishment of the IMT by the Allied powers was lawful because they had only done together what any one of them might have done singly. In terms of the substantive law, the IMT articulated its understanding of the law it was asked to apply. With respect to crimes against peace, it found that war is essentially an evil thing. Its consequences are not confined to the belligerent states alone, but affect the whole world. To initiate a war of aggression, therefore, the tribunal concluded, is not only an international crime, but the supreme international crime, differing only from other war crimes in containing within itself the accumulated evil of the whole. Although this pronouncement conflates war crimes and aggression and has therefore been criticized by scholars, its essence is powerful. As for the other 2 crimes chargeable, the judgment was perhaps less progressive in certain respects, particularly regarding the crimes against humanity counts, which it limited to acts committed against civilians after the onset of the war, in spite of language in the Charter to the contrary. Yet even with these deficiencies and imperfections, 70 years later, we still study, discuss, and even revere Nuremberg. For separated from its all too human flaws, the decision to hold trials and the accomplishment of the task to a high level of professionalism and distinction represented an extraordinary achievement. It may have been an American show in terms of material support and the size of the various participating prosecutorial teams, but it built upon decades of European thought, which following the failed experience of World War I had endeavored to fortify the emerging structure of international criminal law. Building upon this legacy, Nuremberg taught us to reconceptualize the notion of war and its worst consequences, as well as reframe our response to it. But the question remained after whether Nuremberg would simply be a one-off kind of experience, a nice historic event, or whether it would have enduring relevance in the post-war era, and I now turn to that issue. The decision to hold the trials was taken contemporaneously with the San Francisco Conference establishing the United Nations. The principles of Nuremberg are thus deeply intertwined with the organization of the United Nations as the twin foundations of an international society ordered by law. We see this in Article 2.4 of the Charter, prohibiting the use of force. We see it in the limited exceptions to that prohibition codified in Article 51 and the powers of the Security Council in Chapter 7. Likewise, the UN Charter incorporates provisions, albeit limited, on the importance of human rights. Indeed, modern human rights law, like modern international criminal law, rests upon the Nuremberg Foundation, for the notion that individuals can acquire duties under international law only makes sense if they can also acquire rights thereunder as well. The Nuremberg Principles were prepared by the International Law Commission and presented to the General Assembly after the war, and at least some aspects of the law enshrined in the Charter and judgment found their way into new international instruments on apartheid, genocide, the laws of war, and torture, although aggression and crimes against humanity were never the subject of specialized conventions. The Nuremberg Principles eschew collective responsibility in favor of individual responsibility, provide that no human being is above the law with respect to the most serious crimes of concern to humanity as a whole, and the crime of aggressive war crimes, crimes against humanity and aggressive war, and that reliance upon internal law is no defense to crime for which an individual may have responsibility under international law. Thus, at the international level, the Nuremberg Principles became an essential part of the New World Order, but their implementation ran aground on the shoals of state politics. The permanent members of the Security Council were often divided, which meant that the ILC's work on the Draft Code of Crimes and the Statute of an International Criminal Court were largely unsuccessful. The Nuremberg Principles were also often honored in the breach. The United States invaded Vietnam, the Soviet Union invaded Afghanistan. Neither state appeared to understand, or perhaps to care, that the Nuremberg Principles were applicable to those wars. Finally, in the 1990s, as war broke out in the former Yugoslavia and the Rwandan genocide sickened and shocked the world, the international community, freed from Cold War politics, reached for the Nuremberg precedent and established for the first time since 1945 international criminal tribunals. The Yugoslavia and Rwanda tribunals had similar but not identical jurisdictions to the IMT, although neither tribunal included crimes against peace in their statutes. Although both tribunals suffered the same human difficulties experienced at Nuremberg, both ultimately were able to establish themselves as credible and successful international institutions, trying scores of defendants and creating important precedents which have added depth to our conceptual understanding of international criminal justice and the substantive law of war crimes, crimes against humanity and genocide, as well as international criminal procedure. Building upon this foundation, in 1998, a statute for a permanent international criminal court was adopted after years of difficult negotiations. The ICC now has 123 states parties, and the substantive law of the court is widely cited by national and international courts and tribunals, even including, for example, U.S. federal courts. Returning to the question of Nuremberg's impact on national jurisdictions, prior to establishment of the ICC in 1998, the Nuremberg Principles were, to quote Claude Lambois, the famous French jurist, like a volcano, dormant but not extinct. And indeed, after the post-war trials, of which there were thousands all over the world, Nuremberg and its teachings seemed to be forgotten as nations recovered from the pain and suffering of the war. That changed in 1961 when Israel abducted Adolf Eichmann from Argentina and charged him with crimes under Israeli law, including crimes against humanity and war crimes. His trial was widely covered in the media, and many credit the Eichmann trial with forcing Germany to confront its Nazi past as well. Likewise, in the 1970s and 1980s, France began the process of bringing its World War II collaborators to justice using the Nuremberg Charter as incorporated into French law in the cases brought against Klaus Barbie and Paul Touvier. Although Barbie, like Eichmann, was a case in which the state was comfortable because the defendant was not of the same nationality as the victim, the Touvier case, begun in 1973 and ultimately decided in the late 1990s, was indeed a case in which a French World War II collaborator was indicted and convicted of crimes against humanity for acts carried out against French victims. We can also put the Pribke case, brought by Italy, and the Finta case by Canada in the category of state prosecutions arising out of the World War II experience. In Latin America, many prosecutions and truth commissions were undertaken or extradition requests involved in Argentina, in Chile, in Uruguay, in Peru, Mexico, and Brazil, to name a few, relating to crimes committed not during World War II, but in those countries, especially during the Dirty War in the 1970s. The Pinochet case is perhaps the most famous of the cases arising out of the Latin American experience and involved not only the exercise of universal jurisdiction over the crime of torture in European states in which the cases were brought, but ultimately prosecutions in the Chilean courts themselves. More recently, Guatemala's Attorney General brought a case against President Rios Montt for genocide against the Mayan people. The Nuremberg Principles also found their way into the international human rights bodies. Both the European and Inter-American Courts of Human Rights and the Inter-American Commission have developed a broad jurisprudence on many international crimes, both in terms of elements, modalities, and potential amnesties for such crimes. The case law has become so extensive that my colleague Alexandra Hunius refers to these as quasi-criminal jurisdictions that are in fact enforcing international criminal law. In Africa, we've seen the Hissène Habré trial, which followed Belgium versus Senegal, and the ICJ's decision that Senegal had an obligation to either try or extradite Habré under the Torture Convention as very important. Likewise, the establishment of the Special Court for Sierra Leone as a mixed jurisdiction is another way of internalizing the Nuremberg Principles, as has been the widespread ratification of the ICC statute on the African continent. In Asia, although ICC ratification rates are relatively low, a new edited volume by Kirsten Sellers entitled Trials for International Crimes in Asia suggests that although Asian states may be more likely to view international trials with skepticism, in fact, they have often conducted national trials. She points to the in absentia trial of Pol Pot in Cambodia as one example, suggesting that it was, quote, the unsound sequel to the Eichmann trial, but the overlooked prequel to the ECCC. Likewise, the book includes chapters on the influence of the Tokyo trials in modern international criminal law, the Bangladesh experience, Indian and Indonesian proceedings, and the special panels for East Timor. So with all this ferment of activity at both the national and international levels, is the Nuremberg legacy under threat today? I have two sets of concerns in this regard. The first is the unfinished business of Nuremberg itself, and the second is the challenges to the legacy by the behavior of states. Turning to the question of unfinished work, in spite of all the achievements that I've just noted, which are just a sample of the Nuremberg Charter's influence upon our modern world, it seems there is work remaining to be done. The first task is to truly universalize the legacy and the message of Nuremberg, so it is no longer an American or a Western show, and your conference today is a fantastic example and step forward in that respect. The second task is to complete the normative framework of the Charter and enhance the effectiveness of the institutions charged with its application. This means continuing to press for universal ratification of the ICC statute. In terms of substantive law, the laws of war are widely codified, but there do remain gaps, and there is a continuing need for vigilance. Many states are developing restrictive definitions of proportionality to justify attacks that kill large numbers of civilians or target civilian objects, broadening the notion of combatants to expand the range of permitted lethal targeting, and developing dangerous new weapons systems. Nuclear weapons, in particular, remain a constant threat not only to our safety, but to humanity's survival. The rules relating to non-international armed conflict are less developed than the rules on international armed conflict, and the so-called global war on terror has undermined the consistent meaning and application of IHL, a point to which I will return presently. In terms of aggression, progress has been made, but questions remain. We do not yet have the requisite number of states to activate the ICC's jurisdiction, but it seems likely that we will by 2017. Hopefully, states will not try to opt out of the amendments en masse. Moreover, it's troubling that when the Kampala amendments were adopted, understandings were attached that were regressive, providing, among other things, that there is neither the duty nor the right for states to exercise domestic jurisdiction with respect to acts of aggression committed by other states. This essentially means that aggression, unlike the other jus cogens crimes, will not be a universal jurisdiction crime. The clear intent of the understanding is to make sure there is no Pinochet moment with respect to the crime of aggression. Finally, with respect to crimes against humanity, it is stunning that in a world containing more than 300 international criminal law conventions, covering everything from cutting submarine cables to terrorist bombings and genocide, one of the three core crimes of the Nuremberg Trials, and an important crime from the Nuremberg Trials, does not have its own treaty. We saw in Belgium versus Senegal and the Pinochet case how important a treaty basis for jurisdiction can be in international law. Likewise, we saw the absence of a Crimes Against Humanity Convention create difficulties for the ICJ in Bosnia versus Serbia. I'm thrilled that the International Law Commission has taken up the initiative of the Whitney R. Harris World Law Institute that I have the pleasure and honor to direct, and taken up the initiative to draft a new convention on crimes against humanity. So what are some of our current challenges? And I'll try to be briefer here. As Antonio Cassese wrote more than a decade ago, international terrorism is disrupting some important and fundamental legal categories. Recall that when the ICC project was reintroduced to the General Assembly in 1989, it was by Trinidad and Tobago leading a group of Caribbean states which argued that the future International Criminal Court should address the crimes of terrorism and drug trafficking. Terrorism was the subject of an International Court Convention in 1937, but it never entered into force. Terrorism not only harms victims of terrorist acts, but as we have seen, provokes states to launch terrible wars. It is increasingly difficult to understand how terrorism is not one of the, quote, most serious crimes of concern to the international community as a whole, like the other ICC crimes. When the Rome Statute was adopted without the crime of terrorism included, a resolution was appended to the conference's final act, promising to take up the issue in the future. Each year at the annual meeting of the ICC's Assembly of States Parties, states tried to convince other ICC states, to take terrorism seriously. It is, it seems, the scourge of our time, as the recent tragedies of Paris and Beirut demonstrate. Perhaps the states arguing for inclusion of this crime in the ICC statute or for the creation of other international mechanisms to try terrorists have a point. Certainly, the current legal regime is unsatisfactory. Particularly since the attacks of September 11, 2001, the Nuremberg Principles have been undermined by the policies of the very nations that gave them birth, including my own country, sad to say. Recall Jackson's exultation that 4 great nations, flushed with victory and stung with injury, stay the hand of vengeance and voluntarily submit their captive enemies to the judgment of the law, is one of the most significant tributes that power has ever paid to reason. When the United States was stung by the terrible attacks of September 11th, however, reason seemed to be jettisoned as vengeance and even cruelty took its place. Lawyers in the U.S. Department of Justice argue that the U.S. should abandon the provisions of the Geneva Conventions of 1949 in favor of a new legal regime for the detention, treatment, and trial of enemy prisoners, whether captured in the U.S. or abroad. Then counsel to the president, Alberto Gonzales, famously opined that portions of the convention were quaint and obsolete, ultimately persuading the president to deny the applicability of Geneva law to either al-Qaeda or Taliban detainees in U.S. custody. A diplomatic and legal furor ensued, particularly after the transfer of prisoners from Afghanistan to Guantanamo Bay, Cuba, where they were kept in deplorable conditions. The Afghan war was at least, if not authorized by the Security Council, buttressed by it, and important resolutions were adopted, including 1373, that reinforced the Nuremberg paradigm by emphasizing the duty of states to try or extradite suspected international terrorists. But it was followed by the 2003 invasion of Iraq, in which 2 of the 5 permanent members of the Security Council appeared to contravene the prohibition of Article 2.4. Moreover, that invasion was accompanied by high levels of civilian casualties, and as reported by the press and recent congressional hearings in the United States, the apparent adoption of torture as official policy in violation of international conventional and customary law. More recently, the U.S. has engaged in targeted killing by remotely piloted unmanned vehicles in Afghanistan, Pakistan, Yemen, Libya, Iraq, and Somalia, a campaign which often involves high civilian casualties, mistakes, terrorizes civilians in the areas in which the drones operate, and traumatizes the individuals doing the targeting and the killing. The U.S. is not the only member of the P5 that is using its power to avoid being contained by the international legal system. And I also don't want to suggest that these actions are of the same magnitude as the crimes committed during World War II. But they are shocking precisely because they have been undertaken by the United States, a country that endeavors to distinguish itself by its high moral standards, sees itself as a champion of the rule of law, and lent its considerable strength to ensure the success of the Nuremberg Trials. The UK joined the 2003 invasion of Iraq, and Russia and China have vetoed important resolutions on Syria that would have come closer to imposing real consequences for the violence, as well as referring the situation to the International Criminal Court. There is a movement to impose a responsibility not to veto on the Permanent Five, but it's not clear whether that initiative will bear fruit anytime soon. Meanwhile, more than 250,000 Syrians have lost their lives. Millions are displaced all over the world. Russia has apparently annexed parts of Ukraine. The attacks in Paris last week have been discussed at the Security Council, but there has not been a concerted effort to make a legal, as opposed to a policy argument for bombing Syria. Given this record of noncompliance and disrespect for the Nuremberg Principles by the great powers, it is perhaps unsurprising that we find other states following suit. The African Union proposal last year to create a new African regional criminal court that would provide heads of state with immunity from prosecution is just one example. Other countries are retreating from the exercise of universal jurisdiction, even in Pinochet-type cases, and these are worrisome trends. Let me conclude by restating the obvious, that the record of compliance with the Nuremberg Principles is obviously mixed. At the same time, the Nuremberg legacy itself is an extraordinary one, and its importance is hard to overstate. At the opening of today's important meeting, and on the 70th anniversary of the trials, I want to conclude on an optimistic note. We come to meetings like this neither to unthinkingly engage in self-adulation, nor to wallow in destructive self-criticism. Rather, it seems to me our job is to help make international criminal justice stronger, fairer, more effective, and more respected. And this brings me to suggest 3 quick final points. First, we learned from Nuremberg and our subsequent experiences with the ad hoc tribunals that international justice doesn't have to be perfect to be really good. Holding up Nuremberg to an impossible standard is neither fair nor productive. The same is true of the International Criminal Court. Jackson himself argued that he was not asking the tribunal to make war impossible, but to put international law on the side of peace. Second, as I've alluded to, international criminal trials are not the only game in town to enforce the Nuremberg Principles. We have human rights courts, national courts, truth commissions, the International Criminal Court, the International Court of Justice, fact-finding commissions of inquiry, UN human rights bodies, national civil lawsuits, ad hoc and mixed international criminal tribunals. And I'm sure there are others that I have not mentioned or which don't exist yet. To enhance the effectiveness of the Nuremberg Principles, we need to broaden our thinking, get creative, and draw from the rich talent present all over the globe to improve the international criminal justice system. And I dare say we might even do better than they did at Nuremberg, because we're able to tap into an additional 50% of the talent who are women, something they seem to have overlooked at Nuremberg. Finally, we cannot let ourselves forget that the Nuremberg Trials and 50 years later the establishment of the International Criminal Court were nothing short of miraculous. Neither were foreseen by many knowledgeable observers at the time. Today is a day to honor and to celebrate those extraordinary events and honor the memories of the trailblazing individuals that came before us. It seems only proper to remember our dear friend and colleague, the late Judge Hans-Peter Kaul, who was so firmly committed to the Nuremberg Principles and felt that the trials were an historic must. In his lecture to this Academy in 2012, he wrote that he felt that the dramatic encounters here in Nuremberg, the shocking look into the mirror of the Nazi crimes, was a necessary catharsis for the German people. And likewise, I would like to evoke the memory of former Nuremberg prosecutor Whitney Harris, who wrote in 1999, "Nuremberg in 1946 and Rome in 1998 stood fast against the pressures of the precedents of the past. Nuremberg refused to apply executive punishment against its vanquished enemies, according them the rights of accused persons under the law. Rome rules that every person is subject to the law. Nuremberg and Rome stand against the resignation of humankind to its self-debasement and self-destruction. The achievements of that great trial and historic conference in elevating justice and law over inhumanity and war give promise for a better tomorrow." Friends and colleagues, Your Excellencies, ladies and gentlemen, it has been a thrill for me personally to make the pilgrimage to this place, to engage in these conversations, to participate in your meetings. I'm sure that our meetings today and over the next 2 days will be fruitful and remain deeply honored to have been invited to address such a distinguished and accomplished group. Thank you so much for your kind attention.